Hello, this is PNRV Prasad. I'm a practicing advocate and I am online today to talk to you all about how media trials are happening. And one of the most important case that we are all going through is the Nara Chandrababu Naidu Garu's case, the quash petition that was filed in the Honorable Supreme Court stating that Section 17A is applicable to that particular case and that the FIR, the remand report, needs to be quashed. The stage of the case is presently it's reserved for judgment. Both the counsels, senior counsel Sri Hari Salve on the CBN side, Chandrababu Naidu's side, and senior counsel Mukul Rahotogi for the state side have submitted their arguments, submissions very extensively and in depth. So now it's resting for judgment. The bench has to pronounce judgment. Now after the bench has reserved the case for its judgment, I was horrified, I was surprised, I was shocked to see how the breaking news and the debates were happening on the TV, in the media, electronic media particularly. Because I was watching them. Now we have some media which is pro-CBN and some media which is pro the state of AP. Now the media which is pro to CBN were debating on screen about what type of questions have the bench or the judges asked and how were the answers that was coming up and why that questions were asked and how does it help the fact that Chandrababu Naidu's, it will be a favorable judgment to Chandrababu Naidu. I don't understand how the questions asked by the bench would be treated or would be presumed as a judgment towards that side. And the other part of the media, which is pro-state of AP, had started imprinting on the minds of people that the counsels of Nara Chandrababu Naidu Garu have asked for an interim bail, and since there was no consideration of that prayer, the judgment would be pro-state. It's quite alarming. In my law school days, when I was reading law or I was learning about the roots of the law, I was told on matter of principle that when a matter is sub judice, that means that when the matter is in the court or is in consideration before the court, we need to be very careful about what we are talking about that particular case, because that might impact the society as such and the institutions as such. Now all that is bygone. I don't think anyone is heeding to that principle of having a cautious approach to a particular case when the matter is sub judice. In the debates on the media, whether it is pro-CBN or pro-state of AP, including the national channels in some cases, people in the panel who sit and debate actually bring a cross-section of the trial's records, the statements of the witnesses, the questions asked, the literature that exists, the evidence that can be taken, the evidence that cannot be taken, why the court should give this judgment, how this will affect that judgment. Is this very necessary for us? We all respect judicial institutions, and we should. As a matter of fact, when the matter is sub judice, is there a need to talk about the evidential factors that would affect the kind of judgment? Supposing for a reason, if I talk about pro and I get a negated judgment, how would something be felt about? Are we not demeaning the institution like that? The one institution that safeguards the constitutional rights, the one institution that safeguards the entirety of the Constitution. Are we not putting it in such a place, constrained space, when we are debating and the whole trials happen on the media? In my opinion, very humble opinion, very respectfully, I would state the fact that whether it is electronic media or print media or any other media, social media, should self-regulate on the principle of the position that when the matter is sub judice, that particular matter or the case should be dealt with very less depth and with lot of caution. I feel very bad. It's very shocking to me. As an advocate, I really don't know why such things are happening on the media. I just wanted to share this with you all. I don't know whether I am right or wrong, but I am respectfully putting my opinion, and I respectfully feel that there should be no media trials at all. When the matters are sub judice, we keep calm. When the matters are reserved for judgment, we don't presume, we don't predict, and we don't find the probability of this side or that side. That self-restraint should be there in the individual, should be there in the society, should be there in the media, print, electronic, social, any other media otherwise. Thank you so much.